Statements that are non-hearsay under the federal rules. Despite meeting the common law definition of hearsay, the following statements are not hearsay under the federal rules and are therefore admissible as substantive evidence. 1. Prior statements by witness. 2. Statements by or attributable to an opposing party. 3. Vicarious admission. Actually, that's C within 2. What's 3? There is no 3. There's just a lot under statements by or attributable to opposing party. You have 1, judicial and extrajudicial admissions, adaptive admissions from silence as 1, vicarious admissions from co-parties, authorized spokesperson, principal agent, partners, co-conspirators, and those in privy. And so for going back to 1, prior statements by witness, under the federal rules, a prior statement by a testifying witness who is subject to cross-examination is not hearsay if the prior statement is inconsistent with the declarant's in-court testimony and was given under penalty of perjury at a prior proceeding. The prior statement is consistent with the declarant's in-court testimony and is 1, offered to refute a charge that the witness is lying or exaggerating because of some motive, and the statement was made before any motive to lie or exaggerate arose, or 2, offered to rehabilitate a witness whose credibility has been impeached on some other ground other than the general attack on the witness's character for truthfulness, such as an inconsistency or sensory deficiency, or 3, a prior statement is one of identification of a person as someone the witness perceived earlier, even if the witness cannot remember the identification. Exam tip, remember that these 3 hearsay exclusions apply to statements of testifying witnesses only. So there's 3 different kinds. Don't be fooled by an out-of-court statement of identification made by a non-testifying declarant. So there's 3 different kinds of these prior statements by witness, but they're all testifying witness. One is the inconsistent, one is the consistent, and one is for identification. Unless there's, the consistent one has to do with multiple reasons why it would be produced. So for statements by or attributable to an opposing party, which is also non-hearsay, is called admissions, is otherwise called admissions by party opponent. An opposing party statement, for example, any statement made by a party and offered against that party is not hearsay under the federal rules. These statements are traditionally called admissions of a party opponent. To be an admission, the statement need not have been against the declarant's interest when made and may even be in the form of an opinion. Personal knowledge is not required. The admission may be predicated on hearsay. The following types of admissions merit special attention: judicial and extrajudicial admissions. Formal judicial admissions, i.e. pleadings, stipulations, etc., are conclusive. Informal judicial admissions made during testimony and extrajudicial evidentiary admissions are not conclusive and can be explained. Adaptive admissions. A party may make an admission by expressly or impliedly adopting or acquiescing in the statement of another. Silence. If a reasonable person would have responded and the party remained silent in the face of accusatory statements, his silence may be considered an implied admission. Silence is treated as an admission only if the party heard and understood the statement, the party was physically and mentally capable of denying the statement, and a reasonable person would have denied the accusation. Note that silence in the face of accusations by police in a criminal case is almost never considered an admission of a crime. Vicarious admission. Co-parties. Insufficient relationship. Statements of a party are not receivable against her co-parties merely because they happen to be joined as parties. Authorized spokesperson. A statement of a person authorized by a party to speak on his behalf. For example, statement by a company's press agent can be admitted against the party as an admission. Principal agent. Statements by an agent or employee concerning a matter within the scope of her agency or employment made while the agency or employment relationships exist are not hearsay and are admissible against the principal. Partners. After a partnership is shown to exist, an admission of one partner relating to matters within the scope of the partnership business is binding upon her co-partners. Co-conspirators. Admissions of one conspirator made to a third party in furtherance of a conspiracy to commit a crime or civil wrong at the time when the declarant was participating in the conspiracy are admissible against co-conspirators under the federal rules. The court must use the co-conspirator statement itself together with other evidence to determine whether the statement is admissible. For example, the proponent is now limited only to independent evidence to show that the conspiracy existed and that the declarant and party are participants, privies in title and joint tenants. This is in parentheses here, applicable to state courts only. In most state courts, admissions of each joint owner are admissible against the other, and admissions of a former owner of real property made at the time she held title are admissible against those claiming under her, grantees, or heirs. These statements are not considered admissions under the federal rules, but may be admissible under one of the hearsay exceptions, which is a statement against interest, for example. Preliminary determinations. Before admitting a hearsay statement as a vicarious admission, the court must make the preliminary determination of the declarant's relationship with the party against whom the statement is offered. In making such a determination, the court must consider the contents of the statement, but the statement alone is not sufficient to establish the required relationship. Hearsay exceptions when the declarant is unavailable. There are 5 important exceptions to the hearsay rule that condition admissibility of the hearsay statement on the present unavailability of the declarant to testify. Unavailability. A declarant is unavailable if he is exempted from testifying because of privilege, refuses to testify concerning the statement despite a court order, testifies that he does not remember the subject matter, is unable to testify due to death or physical or mental illness, or is absent and the proponent is unable to procure his attendance or testimony by process or other reasonable means. A declarant who is able to give deposition testimony in lieu of attending is considered to be an available witness except with respect to the former testimony, and forfeiture by wrongdoing exceptions discussed in 2 and 6 below. So that's a definition of unavailability. Former testimony. The testimony of a now unavailable witness is admissible if the testimony was given under oath at a trial hearing or deposition in the same case or in a different case, and the party against whom the testimony is now being offered, or in a civil case, the party's predecessor in interest includes grantor, grantee, and other privy relationships, has an opportunity and similar motive to develop the declarant's testimony at the prior proceeding by direct cross or direct redirect examination. Exam tip on a practical level. The opportunity and similar motive requirement means that the party against whom testimony is offered or her predecessor in interest must have been a party in the former action, and the former action must have involved the same subject matter because the causes of action need not be identical. Exam tip 2 for this general hearsay exception section, I think, or just the former testimony section, because grand jury proceedings do not provide the accused with an opportunity for cross-examination. The grand jury testimony of an unavailable declarant is not admissible against a defendant under the former testimony exception to the hearsay rule. Be careful not to confuse this with a prior inconsistent statement given under oath by a witness currently testifying. Grand jury testimony is admissible in that case, both as impeachment and substantive evidence. Interesting. Statements against interest. A statement of a person now unavailable as a witness may be admissible if it was against that person's pecuniary, proprietary, or penal interest when made, such that a reasonable person in the declarant's position would have made it only if she believed it to be true. The declarant must also have had personal knowledge of the facts and must have been aware that the statement was against her interest when she made it. Statements subjecting the declarant to criminal liability. In criminal cases, the federal rules require corroborating circumstances, indicating the trustworthiness of statements against penal interest. Statement means single remark. If a person makes a declaration containing statements that are against his interest, I sold drugs, the statement that are not, X runs the drug ring, the exception covers only those remarks that inculpate the declarant, not the entire extended declaration. Statements by an opposing party versus statements against interest. Statements by opposing party. Statement need not have been against interest when made. Declarant need not have personal knowledge of facts. Declarant need not be unavailable. The declarant must be a party. Whereas with statements against interest, the statement must have been against the interest when made. Declarant must have personal knowledge of the facts, and declarant must be unavailable, and the declarant need not be a party. So they're completely different. Dying declarations, statements under belief of impending death. In a homicide prosecution or in any civil action, a statement made by a unavailable declarant is admissible if the declarant believes his death was imminent, he need not actually die, and the statement concerned the cause or circumstances of what he believes to be his impending death. Note that the statement must be based on the declarant's perceptions and first-hand knowledge of what happened. For example, an unsupported opinion or speculation will not qualify. Exam tip. The bar exam may require you to distinguish the federal rule on dying declarations from the traditional rule. Beware of answer choices reflecting the traditional rule, which required that the declarant ultimately die of the injury, and 2 could not be used in civil cases. And remember, although the dying declaration exception may be used in any civil case, its use in criminal cases is restricted to homicide prosecutions. There are no dying declarations in prosecutions for attempted homicide. Statements of personal or family history. Let's just finish this. Statements by a now unavailable declarant concerning births, marriages, divorces, relationship, genealogical status, etc. are admissible provided that the declarant is a member of the family in question or intimately associated with it, and the statements are based on the declarant's personal knowledge of the facts or her knowledge of family reputation. Statements offered against party procuring declarant's unavailability. A statement of a person now unavailable as a witness is admissible when offered against a party who has engaged or acquiesced in wrongdoing that initially procured the declarant's unavailability. Okay, by wrongdoing. And here's the exceptions. Unavailability being required is former testimony, statement made under oath at the same or at other proceeding in which the party against whom it is offered had motive and opportunity to develop testimony. Statement against interest, statement against declarant's pecuniary, proprietary, or penal interest when made. Dying declaration, statement made when declarant believed death was imminent concerning the cause or circumstance of the impending death. Statement of personal or family history, statement of personal or family history, example, birth, death, marriage, made by a family member or one intimately associated with the family, and statement offered against party procuring declarant's unavailability. Statement of unavailable declarant offered against party who intentionally procured declarant's unavailability. Now we'll go into declarant's availability immaterial, hearsay exceptions, and another recording, because ultimately I do have somewhere to be, but we'll leave us with 10 more pages, and we could, if time avails, return to the privileges, not very long 2 pages that I skipped earlier.